The Supreme Court went dead silent. Chief Justice John Roberts, known for his poker face and tight control of the courtroom, suddenly took off his glasses and leaned forward. He stared right at Representative Jasmine Crockett, who stood calmly at the podium. What started as a normal hearing on voting rights was about to become a moment lawyers would talk about for ages. Representative Crockett, the Chief Justice said, his voice clear in the quiet room. I have to say, I've rarely seen such clear thinking under such tough questioning. The crowd looked surprised. Chief Justice Roberts wasn't known for giving compliments during argument, but what happened next floored even the most experienced legal reporters. The Chief Justice nodded slightly to Crockett, a gesture that spoke volumes in the court's formal setting. In that instant, a freshman congresswoman from Texas had earned something almost no advocates ever get: the open respect of the nation's top judge. If you want to know what Representative Crockett said to get such high praise from Chief Justice Roberts and the lasting impact of this courtroom scene, hit the like button and subscribe for more in-depth coverage of the key cases shaping our country's legal landscape. To really appreciate this courtroom exchange, we need to understand the two people at the center of it and the important case that brought them face to face. Since 2005, Chief Justice John Roberts has been in charge of the Supreme Court. Born in Buffalo, New York in 1955, Roberts had an amazing legal reputation way before joining the court. After graduating from Harvard Law School, he worked as a clerk for Justice William Rehnquist, held a position in the Reagan government, and became a top appellate lawyer, arguing 39 cases before the Supreme Court. As Chief Justice, Roberts is known for his careful way of handling important matters and his deep concern for how the court is seen. People who study the court have noted that he doesn't like strong language and prefers limited, accurate legal reasoning. Even though President George W. Bush chose him, Roberts has sometimes gone against what was expected, especially when it comes to the Affordable Care Act. Roberts sees himself as someone who protects the court's legitimacy. According to legal expert Lawrence Tribe, he's very careful about keeping the court's reputation intact and rarely shows strong emotions when speaking publicly. On the other side, there's Representative Jasmine Crockett, who has represented Texas's 30th congressional district since 2023. But Crockett's path to Congress was unique. Before entering politics, she built a strong reputation as a civil rights lawyer, dealing with many voting rights cases in the South. Growing up in St. Louis with working class parents, her dad was a mail carrier and her mom was a caregiver. Crockett saw firsthand how voting restrictions affected her community. After getting scholarships to Rhodes College and the University of Houston Law Center, she dedicated her legal career to voting rights lawsuits, especially in communities with a long history of voter suppression. Richard Hazen, a voting rights expert at UC Irvine, said Crockett is great because she knows the law inside and out, but she also gets how these rules affect people's lives. It's not just about court cases for her. She really understands the human side. The case before the court, Henderson Area Ballot Board versus Combined States, was about a local rule that closed over 200 polling places, mostly in areas where people don't have much of a voice. The claim was that it would make voting easier. Even though the rule didn't mention race, it ended up making voters in certain groups travel 5 times farther than white voters to cast their ballot. Lower courts disagreed on whether the rule violated the Voting Rights Act, with one court saying there wasn't enough proof of discrimination. The Supreme Court decided to take the case because it could change voting rights law everywhere. What do you think about rules that make it harder for some groups to vote, even if race isn't mentioned? Have you or anyone in your family ever had trouble getting to a polling place? Share your stories in the comments. Your experiences help show why these important questions matter to everyone. When the arguments began, you could feel the tension in the Supreme Court. The room was packed with reporters, legal observers, civil rights leaders, and local officials. Crockett walked in wearing a simple dark blue dress and carrying just a small folder of papers. Unlike many lawyers who had stacks of materials, Crockett's focus and calm demeanor showed she was ready. Chief Justice Roberts started the questioning. Representative Crockett, your document says this voting site method violates Part 2 of the ballot rights law, even though there aren't any race-based categories. How can you prove it's biased when the writing looks neutral on the surface? Crockett answered this question calmly. Chief Justice, the court's decision in Arlington Heights gives us a way to find biased intent behind rules that look neutral. We have to look at what happened before, any changes from the usual way of doing things, and what the rules really do. She went on on without looking at her notes. In this case, all 4 things point to a biased reason. The region's own planning predicted these closures would affect minority voters 3 times more than other voters. Other ideas that would have worked just as well without such a big difference were offered but turned down for no reason. Justice Samuel Alito seemed unsure. Representative, a connection isn't the same as a cause. Couldn't these differences be because of where people live or other things that don't have to do with race? Justice Alito, I agree that a connection alone isn't enough, Crockett replied, surprising him by agreeing so quickly. That's why we've shown more than just numbers. She pulled out one paper from her folder. This internal memo from the director's office, which we found during discovery, plainly says that the method will greatly lower participation in areas that usually vote Democratic, because there's a strong link between race and political party in this region, which has been written about in several court decisions. This statement is strong proof of a biased reason. Judge Elena Kagan jumped in. The region's advisor claimed money problems forced the closure. What's your take? Crockett's answer was fair but firm. Judge Kagan, the documents show the region set aside $4.2 million for setting up voting spots in mostly white rural areas, while claiming money problems made them shut down sites in minority areas. This goes against their money excuse and suggests a biased reason. Judge Neil Gorsuch, a stickler for the text of the law, pressed harder. Representative, the law itself doesn't mention race. Are you asking us to look beyond the law to figure out what they meant? Wouldn't that go against our textualist principles? Crockett replied. Judge Gorsuch, sticking to the text doesn't mean ignoring the situation. In community of Arlington Heights, this court admitted that rules that look fair on the surface could be a cover for racial bias. The text is key, but this court has often said that the Constitution bans both obvious and subtle forms of bias. Gorsuch kept pushing more forcefully. But where do we draw the line? How do we tell when an imbalanced outcome becomes biased intent without just substituting our judgment for the legislatures? Crockett stood his ground. The proof draws the line, Judge Gorsuch. We've got recent statements from officials, rejected plans with less of an imbalanced outcome, and weird stuff in how the rules were approved. These aren't just our opinions, they're objective signs that this court has long considered proof of biased intent. Judge Brett Kavanaugh switched gears. Let's talk solution. If we find a violation of Part 2, what's the right fix? Wouldn't we be creating policy by ordering where voting sites should be? Not at all, Judge Kavanaugh, Crockett said. The solution would just require the region to use a method for placing voting sites that doesn't unfairly burden minority voters. Then the area would still have total freedom in how they meet that basic requirement. Courts have handled similar solutions for ages without making policy. The questioning went on really intensely for over 40 minutes. The judges looked for any mistakes, but Crockett had answers ready. She used basic rules, examples from other cases, and facts that seemed to cover everything they threw at her. Judge Amy Coney Barrett asked about the past. She said, how much should we care about old biases in an area when we're looking at a rule that seems fair now? When does the past not matter anymore? Crockett replied. The past matters most when it's still causing problems today. Here we've seen how housing segregation from the past still affects where people live now, and that affects which communities are hit hardest when voting places close. This isn't ancient history, it's still happening. Then came the moment everyone would remember. Chief Judge Roberts, who had been very involved in the debate, brought up a tricky scenario that would challenge even the best lawyers. He said, let's say a county uses a rule that seems fair to everyone for deciding where to put voting locations, like one voting place for every 5,000 registered voters. If this leads to fewer voting places in minority areas because fewer people there are registered due to past discrimination, would that be discrimination? The room got quiet. Roberts was known for using these kinds of scenarios to find holes in people's arguments. This question required to handle complicated ideas while focusing on the real results. Crockett paused to think before answering. Chief Judge Roberts, this question gets to the heart of what experts call second-generation voting discrimination. These are strategies that use existing social trends to create unfair results for minorities while seeming innocent. She continued, very well. Based on previous court cases, I would see if the county knew or should have known that this would happen before they made the rule. If officials knew their rule would create big differences between ethnic groups but did it anyway, especially if there were other fairer options, then we can say they had discriminatory intent. And that means we need to take a closer look. Roberts pushed. But where do we draw the line? Can almost any decision about managing ballots be challenged if it leads to some kind of difference in numbers? Right then, Crockett showed how well she could balance being fair in court with saying things practically. The line, Mr. Chief Justice, is incorrectly applied Arlington Heights standards, she said. Not every difference in outcome means there was a biased reason. Some are just unexpected or unavoidable results of a good plan. The Constitution doesn't promise equal outcomes all the time. She paused, then kept going with more conviction. But when an area knows for sure that its chosen way will seriously burden the basic right to vote for people who aren't well represented, when there are fairer ways to meet legal goals, and when the area ignores those ways without a good reason, especially if there's a history of bias, the Constitution can't stay quiet. As Crockett spoke, the courtroom was completely still. Even judges who clearly disagreed with her seemed hooked by her reasoning. The 15th Amendment's rule against denying or limiting the right to vote based on race wasn't just about obvious racial categories. She went on, the people who wrote it knew that voting rights could be weakened in sneaky ways just as much as by direct bans. That's why they used the broad words denied or abridged instead of narrower terms. Crockett finished with quiet power. When modern methods lead to the same biased results as the old poll taxes and literacy tests, they must face the same constitutional judgment. If not, we turn the 15th Amendment into just a show that bans only the most obvious kinds of bias while letting the same effects happen. Judge Clarence Thomas, who didn't often speak during arguments, surprised everyone by asking a simple question. Representative Crockett, many of these counties have had the same polling places for years. What specific proof is there that closing them now as part of a statewide plan to be more productive shows intentional bias instead of just neutral management? Crockett turned to Judge Thomas and said plainly, Judge Thomas, there are three especially convincing pieces of evidence. First, the region's own data showed that these shutdowns would hit minority voters way harder than white voters. Second, internal records show that when this disparity was pointed out, the leader said, we can't control who votes. And third, other plans that would have saved just as much money without messing with minority voters as much were suggested, but then rejected without a good reason, she said. Maybe what's most telling, Judge Thomas, is that the areas hit hardest by these shutdowns has seen the highest minority voter turnout in the last two elections. Scheduling these shutdowns right after that historic turnout is a pretty strong clue that there was bias at play. Based on this court standard, Thomas nodded slightly, looking alert but hard to read. Judge Sonia Sotomayor jumped in. Representative, how do we balance the region's need to run elections smoothly with the potential burden on minority voters? Crockett replied, Judge Sotomayor, efficiency and fairness don't have to be at odds. The documents show that Plan C would have saved 92% of the money while reducing the impact on minority voters by over 70%. When solutions like that are available, regions can't just say that bias is the price of saving money. As she finished speaking, Chief Judge Roberts sat still, deep in thought. The usual rapid-fire questioning that defines Supreme Court arguments had given way to a rare moment of quiet contemplation in the nation's highest court. The region's Attorney General approached the podium to argue his side, but it was clear that the momentum had shifted. Judge after judge pressed him on the points Crockett had brought up, especially the rejected alternatives and the internal discussions about political impact. If your region knew these shutdowns would disproportionately affect minority voters and had other ways to save money without that happening, why were those alternatives dismissed? Judge Sotomayor asked directly. The Attorney General was struggling to give a good answer, always going back to how the law looked. Fair on the surface, he said the law didn't sort people by race. Courts should be very cautious about assuming bias just because there's an unequal result. Judge Kagan cut him off. But we're not just talking about unequal results, are we? Representative Crockett had notes showing they knew the law would affect people based on race, talks about rejecting better options, and weird stuff in how the law was passed. How do you explain that? She asked. Those were just early versions, the poor Attorney General replied, sounding less sure of himself. They don't show what the lawmakers finally decided, but they do show they knew what might happen, Judge Barrett. Ow said. Doesn't that matter legally? The Attorney General switched gears. Your honors, even if the court finds a problem here, the fix should only apply to the specific areas with unequal results, not get rid of the whole thing. Judge Roberts, usually respectful of local governments, jumped in surprisingly directly. Counsel, you haven't explained Crockett's proof that your region knew about the unequal results but didn't bother wanted to look at better, less biased options. How does that fit with your claim that any unequal effect was accidental? Sir Judge, the Attorney General replied, clearly annoyed. Managing elections means making tough choices. The lawmakers considered lots of things not in the documents, including which voters would have harder time voting. Judge Kavanaugh asked sharply, was race one of those things? No, Your Honor, definitely not, the Attorney General insisted. The method was based only on efficiency and cost. But Method C, which Representative Crockett mentioned, would have been as efficient with way less unequal effect, Judge Gorsuch pointed out. Why wasn't that method picked if the goal was really efficiency and not reducing participation in certain areas? The Attorney General shuffled through his papers. I don't have the details on Method C here, Your Honor. As his argument fell apart, even judges who were expected to side with the region started asking harder questions. The Attorney General, who walked in confident, now looked like he was having a hard time defending himself against the proof Crockett had shown. Judge Thomas, who had been paying attention the whole time, asked what would be the most telling question of the argument. Counsel, if we agree with you that only obvious racial classifications trigger tough reviews, aren't we basically telling regions how to get around the 15th Amendment by using neutral sounding laws with known biased results? The courtroom went silent. Coming from the court's most conservative member, this question showed a big change in the dispute's direction. Judge Thomas started, the courts always needed proof of bias, not just unequal results. Isn't that what Representative Crockett gave us today? He pointed out that internal discussions showed they knew the ethnic impact, rejected fairer options, and that past actions suggested a pattern. The lawyer general had no good response. When Crockett gave her final statement, the room went silent. The question here is whether our Constitution lets states do indirectly what they can do directly, she began. The evidence shows the state knew their plan would hit underrepresented voters hard, turned down less biased ideas, and went ahead anyway. She continued with quiet conviction. Throughout our history, the right to vote has been challenged over and over, from wealth and poll taxes to literacy tests and now these new administrative roadblocks. The method changes, but the result's the same. This isn't about whether states can try to run elections well. Of course they can. It's about whether they have to do it in a way that doesn't unfairly burden the voting rights of underrepresented people. She finished with a steady confidence. The 15th Amendment doesn't just ban open discrimination. It promises that everyone has equal access to voting, not just on paper, but in reality. The voters in my district and across the affected state just want this court to make that promise real. As she sat down, Chief Justice Roberts took off his glasses and set them down carefully. Looking right at Crockett, he said something that will be quoted in law books for years. Representative Crockett, he said, his voice clear. I rarely see such clear thinking during such tough questioning. The court will hold off on its decision, but your presentation today was a model of great advocacy. The statement hung in the air. Supreme Court justices just don't give praise like that during argument. Their strict rules usually stop any sign of personal views until written rulings come out. Crockett, surprised, quickly collected herself. Thank you, Chief Justice, she said with respect. I appreciate your words, but what matters is whether this court will protect the right of every citizen to have their vote count free from unfair barriers. The 1.7 million people hurt by these voting site closures aren't worried about legal language. They just want their right to vote honored and protected. It was this response, steering attention from personal praise to the principles at stake, that led to Roberts' unusual show of respect. The Chief Justice nodded slightly to Crockett, a small but meaningful acknowledgement in the formal setting of the Supreme Court. The Chief Justice then turned to the other justices, looking thoughtful. I think we've heard strong arguments from both sides today. This case raises tough questions about our commitment to equal voting rights and the role of this court in protecting them. Court watchers with years of experience exchanged surprised glances. Reporters wrote quickly. In the audience, civil rights experts who had seen many voting rights cases wiped away tears. This wasn't just another Supreme Court case. It was a moment when the nation's highest court recognized something important about our values, that its greatest promise lies not in abstract rules, but in making sure those rules protect the rights of every citizen in their everyday lives. The impact of that remarkable Supreme Court clash between Chief Justice Roberts and Representative Crockett spread through American legal thinking and awareness. As Crockett walked down the court steps, reporters surrounded her. Representative, what does it mean to get such rare praise from the Chief Justice? One shouted. Today wasn't about any one lawyer or judge, Crockett replied, with the same focused principle she showed showed inside. It was about whether our Constitution's promises reach every citizen, regardless of race or where they live. The real triumph will come only if this case helps secure equal voting rights for all citizens. Meanwhile, inside the court, Chief Justice Roberts went back to his chambers, clearly moved by the morning's events. According to an aide who later shared the story anonymously for an article, Roberts sat at his desk for a while in quiet thought before speaking. In all my years on the bench, he reportedly said, "I've never heard someone express so well what the Constitution's promises should mean in practice." Sometimes it takes a fresh voice to remind us of our deepest commitment. The story dominated legal news for weeks. Legal scholars debated the meaning of Roberts' unusual praise and what it might mean for the court's direction on voting rights. Harvard Law professor Lawrence Tribe said, "In my 50 years teaching constitutional law, I've never seen anything like it. The Chief Justice's action goes beyond usual court behavior and suggests a deep recognition that Representative Crockett's argument captured something vital about our values." 8 weeks later, the Supreme Court released its ruling in Henderson County Election Board via United States. In a surprise 6-3 decision, with Chief Justice Roberts writing for the majority, the court struck down the county's voting site plan. When seemingly neutral voting rules create strongly unequal effects along racial lines, Roberts wrote, "Courts must take a hard look at both indirect and direct evidence of discriminatory intent. The fact that a regulation doesn't openly mention race doesn't shield it from constitutional review when the evidence shows that less biased options were available and rejected without good reason." The opinion specifically cited Crockett's argument. As counsel for respondents rightly noted during oral argument, when new methods achieve the same discriminatory outcomes as the poll taxes and literacy tests of the past, they must meet the same constitutional fate. This principle guides our review today for the voters in Representative Crockett's district and across the affected state. The effect was immediate and strong. The court ordered the county to reopen voting sites in affected communities and create a new plan that ensured equal voting access for all residents. When the next election happened, voter participation in formerly affected areas rose by 37% compared to the previous election. People who had faced hours-long trips to vote now found accessible voting places in their community. The Henderson County ruling became a key case in voting rights law cited by courts across the country reviewing seemingly neutral voting rules with unequal effects. State lawmakers began to add unequal impact reviews into their election planning, often inviting civil rights experts to review proposed changes before they were put in place. For Crockett, the Supreme Court win confirmed her approach to constitutional advocacy, one that combines strict legal review with a deep understanding of how laws affect real communities. She continued her work in Congress with renewed determination, focusing on laws that would formalize and strengthen the principles expressed in the Henderson County case. What made Representative Crockett's advocacy so powerful, said Yale Law Professor Heather Gerken, was her ability to link constitutional theory and real-world reality. She didn't just argue abstract legal rules, she showed the court exactly how those rules translate into either protection or hardship for real people. Perhaps the most unexpected result was the unique relationship that developed between Chief Justice Roberts and Representative Crockett. Despite their different legal philosophies, they found common ground in their commitment to constitutional principles and institutional integrity. At Georgetown Law's yearly Constitutional Law Conference the following year, they appeared together in a rare joint discussion led by Jeffrey Rosen of the National Constitution Center. "What impressed me about Representative Crockett's argument," Roberts explained to the packed room, "was not just its legal accuracy, but its fidelity to the Constitution's deepest purpose, making sure that our fundamental rights are protected in practice, not just in theory. Great advocacy lights the path to justice, even when judges might initially see the legal landscape differently." Crockett nodded thoughtfully. "And what I valued about the Chief Justice's approach," she replied, "was his willingness to engage seriously with evidence, even when it might lead to conclusions different from his starting leaning. That intellectual honesty is vital to constitutional understanding that truly benefits the people." The Henderson County case reminded people that our democratic systems can still work as intended when principled advocates submit compelling evidence and thoughtful legal authorities engage with that evidence in good faith. It showed that despite our divided politics, constitutional principles still have the power to overcome political divides when correctly expressed and loyally applied. For the millions of people who had faced barriers to voting, the case symbolized something more direct and personal, the fulfillment of the Constitution's promise that their voices count just as much as those of their fellow citizens who face no such obstacle. As former Attorney General Eric Holder noted in a speech marking the ruling's first anniversary, the Henderson County case reminds us that our Constitution is not self-executing. Its promises demand committed advocates like Representative Crockett, who demand that those promises be kept, and principal legal authorities like Chief Justice Roberts, who are ready to ensure that they are. The legacy of that remarkable Supreme Court clash continues in law school classrooms, where instructors use the record to teach students about persuasive advocacy. In courtrooms throughout the nation, where advocates cite the Roberts-Crockett framework when challenging modern forms of discrimination. And most importantly, in communities where residents now find it easier to exercise their fundamental right to vote. For those who witnessed that remarkable day when Chief Justice Roberts recognized Representative Crockett's outstanding advocacy with open admiration, the memory serves as a gentle reminder that our system functions best when intelligent minds engage with one another in good faith, guided by a shared commitment to constitutional principles and personal integrity. The Henderson County case didn't solve all the problems facing citizen governance. Important questions about voting rights, election administration, and constitutional understanding remain, but it showed that progress is possible when we handle these questions with intellectual honesty, reciprocal respect, and a true dedication to the Constitution's deepest values. In a country often split by political bitterness, the Roberts-Crockett interaction offered a glimpse of a different path, one where principal disagreement need not exclude reciprocal admiration, where constitutional advocacy can enlighten rather than provoke, and where our premier court can achieve its vital function as protector of rights that pertain to all citizens regardless of race, location, or circumstance.